Mr. Ambriano.
Good morning, Your Honor. Anthony Ambriano, representing the Boards of Assessors of the cities of Boston and Cambridge in this matter. The other appellants are the Boards of Assessors of Newton and Springfield. With me is Attorney Richard Chmielewski from the city of Newton. All of the assessors have presented a joint brief to the court. Attorney Chmielewski and I have divided the argument time with respect to issues. Attorney Chmielewski's argument will be focused on the res judicata issues, as mentioned by the Appellate Tax Board in its order. Included within that argument will be whether this court's decision in Bell Atlantic Mobile 1 is dispositive of any of the issues now being presented.
If I could ask, why is not the sensible remedy to simply say the towns and cities can go and value the property because the commissioner no longer has the authority to do so, and go back in time and do the valuation, which they would otherwise have contested at the ATB?
The period of time for the assessors to have made any assessments is long past for the fiscal years at issue.
Okay, how about under Section 77? Have you considered...
Omitted and revised assessments?
No, not Section... That's Section 75, I believe. I'm referring to the reassessments. Every tax which is invalid by reason of error or irregularity in the assessment may, if it has not been paid in full, if it has not been recovered back, be reassessed by the assessors for the time being to the just amount.
That statute, I believe, applies only to assessments made in the first instance by assessors. Under the Section 39 central valuation regime or scheme in effect in the Commonwealth, the assessors are not party to the Section 39 assessments. Those assessments are made by the Department of Revenue pursuant to information that is submitted only to the Department of Revenue by the telephone companies, using that term in its broadest sense for present purposes.
Which you were obliged by law to adopt for purposes of your assessment.
That is correct.
Weren't there some years in here where you did, where some of the cities are, I thought that some of the cities of town did do an independent assessment and sent it to Verizon?
There were, for some of the later fiscal years that were dismissed by the Appellate Tax Board, local assessments were in fact made by some of the municipalities. Those local assessments were made subsequent to the Appellate Tax Board's decision that cellular carriers were not phone companies, and in particular were made after the Department of Revenue issued technical information release in October of 2006. That technical information release does appear in the appendix. And that technical information release provides that final assessment determinations can be made by the assessors in accordance with the DOR central values or local valuations to be made by the local boards of assessors. So until that time, I think the assessors would have been essentially acting rogue to do anything else, and would have certainly been bound by this court's decision that provisions of Section 39 are mandatory, as was found in Springfield versus New England Telephone, 1953 case. And the issue now before this court is what happens procedurally. The Department of Revenue has said that Bell Atlantic Mobile was a phone company, that therefore it was entitled to certain corporate utility exemptions, and here is the value. Now we know in April of 2008, this court held that Bell Atlantic Mobile was in fact, for purposes of local taxation, not a phone company. The Appellate Tax Board has taken the position that if they're not a phone company, that the Appellate Tax Board does not have jurisdiction and cannot reach the other issues that have been raised by the assessors. That is, the wrongful exemption of the machinery of the taxpayer, as well as the valuation of that machinery. And the assessors suggest that there's...
Is part, just to go back though, is part of the record before the dismissals there's factual information about how the assessors would have valued this, assuming that the central valuation didn't apply?
Yeah, to answer your question, no, and the reason is this. After this court's decision in Bell Atlantic Mobile 1, the Appellate Tax Board scheduled a status conference
Right?
to discuss the pending appeals under Section 39 filed by both taxpayers and by assessors, together with appeals filed by taxpayers under Sections 64 and 65, the
Right.
traditional method of appealing. At that hearing, Newton and Boston filed motions to consolidate their Section 39 appeals with the Section 65 appeals that had been filed by the taxpayers. At that hearing, the transcript of which is quite brief and which is included in the appendix, the board, sua sponte, without the benefits of briefs on the issue, without the benefits of any notice having been given to any of the parties, essentially said, the board will dismiss.
No, I understand that, but I guess what I'm getting at is, isn't the relief you're saying is that you should be able to appeal the other parts of your original Section 39 appeals, right?
That is correct.
And my question is, at the time when you filed those Section 39 appeals, is there an adequate, let's just assume for the minute that we disagree with the board, is there an adequate record for you to get the relief you're seeking, or do you have to add stuff to it?
No, essentially, and not all of the municipal pleadings are precisely the same at the Appellate Tax Board, but generally speaking, the assessors claimed in their Section 39 appeals three things: wrongly classified, wrongly exempted, and wrongly valued.
Okay.
So that the pleadings are in place.
But the evidence isn't.
That
So
is,
you'd have to have hearings and produce evidence and have
That-
a whole proceeding.
that would be correct, is that the cases would then proceed.
Now, explain to me these Section 65 appeals. These are taxpayer appeals. Why from what is the taxpayer appealing here? Why aren't these 39 appeals by the taxpayer?
The taxpayers, probably from an abundance of caution, and because they have a right which the assessors don't have.
Well, because it's the assessor's assessments.
Well, it's the assessor's tax bill issued based upon the Department of Revenue's assessments, which I think is an important distinction. The assessors at the first stages are essentially bystanders.
So you're saying out of but they could have appealed under Section 39 as well.
As they did.
They did.
And you could have also assessed outside of the central valuation system, even though because in fact you ended up doing that.
Well, I disagree that could have been done prior to the ATB decision in
But
Atlantic
still, the
Mobile
taxpayer
1.
could have pursued two tracks, 39 and 65.
That is correct, and it's quite clear under the law, and even under the MCI case decided by this court last year, that the Appellate Tax Board cannot raise an assessment under a Section 65 appeal. So that...
But if I can go back earlier, I'm aware of all the statutory morass we're in, okay, but why is not the sensible result here to say you were not able to assess taxes because you were obliged to rely upon the commissioner's assessment because you understood that the commissioner was assessing for you because it was a telephone company? Then the ATB and later this court says, no, the commissioner should not have assessed. You should have assessed. You had no reason to know that at the time. Why not simply for us to say, okay, go back and value it, since why can't you basically value it and then let the telephone company challenge it on a Section 65 appeal?
I think logistically that would be very difficult. We would have to first begin with the discovery process.
But you would have to challenge, right now you're saying we want to challenge the commissioner's valuation. You still have to present evidence to the commissioner that the commissioner's valuation is wrong, so don't you have to do your own valuation to challenge the commissioner's valuation?
That could be done, but I would emphasize again that the primary issue is the one of exemption.
I mean, it's just whether the corporate utility exemption applies or doesn't apply.
That is correct, and based upon ATB decisions, the judgment by this court that they're not a phone company, it is very close to a given at this point that they don't get it.
Okay, so you're essentially going to say, we want your valuation, Commissioner, plus the amount of the corporate, of the exemption. That's what
That
your
is correct.
position's going to be. That's the proper valuation.
That is correct. It's almost a routine formula. Just go back, do what you did, and add in the property, which was wrongly exempted.
And if you were to be valuing it yourself, that's what you would do as a town, wouldn't you?
In all likelihood, such a procedure would be done based upon information supplied by the company.
Okay, and why can't that be the case? Why can't we simply say, you go value it now, and then proceed under Section 65, and they can challenge your finding? Why is that a position that you appear to be unwilling for us to take?
I think essentially it's just, again, practical difficulties of starting more from scratch than we would be. If we were to go back to the Appellate Tax Board on these issues, a board which is statewide jurisdiction, expertise in these areas, say, okay, here is our claim. We have to deal primarily with the exemption issue.
Okay, but the commissioner's valuation is worthless now. The commissioner now has no power to do this valuation. So we've said the commissioner's valuation is of no consequence. So you're basically now challenging and saying we want to adopt a valuation which legally has no consequence. That's the problem with your argument.
Well, I don't think we're not adopting that value. And even
Asking
in
the ATB to adopt it.
none of these value cases have been tried with respect to wireless carriers.
You want us to say you can go back to the ATB and challenge the valuation of the commissioner, which now has no legal consequence.
Well, we would not say it has no consequence. It did have consequences. It had very serious consequences with respect to giving the exemption. And those pleadings are in place. Those petitions are pending now, were pending until they were dismissed, at the Appellate Tax Board.
Are there values, are there accepted values for what was determined to be exempt under the corporate utility exemption?
Well, you will see, and it was brought up in the papers filed by Bell Atlantic Mobile. Subsequent to all this going on, there have been settlements. There are formulas in place going backwards and going forwards, which depend to a certain extent on what this court decides with respect to those fiscal years in which the exemption was granted and for which there were no local assessments. So yes, I think the answer to your question, Justice Botsford, is yes. Things have been, shall we say, worked out. And if the court allows the existing Appellate Tax Board cases to go forward, and we get the train on the track that it's already on, we do that, and the cases can be disposed of in that way.
I'm sorry, you mean there's already a settlement? We just have to say, okay?
Well, it was brought up in the papers filed by Bell Atlantic Mobile that
I
there
realize
have
they've
been
settled some other cases where there were
different fiscal years. That is correct. The later fiscal years have been resolved, and under those documents which are produced in the appendix filed by Bell Atlantic Mobile, this court will note that with respect to the earlier fiscal years in which there were no local assessments, there is a formula in place that will deal with the valuation issues.
You take, for example, the 2007 formula and apply it to 2002. Is that what you're saying?
That is essentially correct, as well as going forward.
If that's all there needs to be done, then why isn't Justice Gantz's solution the correct one?
Well, it's
You've
essentially
already got
forced it.
numbers. Go make the assessment.
Because it's too late.
I believe the assessors do not have the statutory authority 5 or 6 years after the assessment dates at issue to go back and make those assessments at this point. I've gone well over it. Thank you very much.
I'll ask the question that I was going to ask you to Mr. Chmielewski, because Mr. Chmielewski is going to be able to argue. So, Mr. Chmielewski, let me ask you this question. One of the things that the ATB noted, which is a direct follow-up of Mr. Ambriano's answer to Justices Cordy and Gantz, is that the assessors, i.e. you, did not pursue other avenues for challenging the Commissioner's exemption determination. I take it that what the board was saying is, you know, you assessors want us to decide something that we can't decide, and there are other ways that you can challenge that. I don't know what that means. An action for declaratory judgment, an action in mandamus, other judicial proceeding.
With all due respect, Justice Marshall, I think Justice Botsford has it right. There's only one way practically for us to contest it, and that's under 5939, our administrative remedy to contest a central valuation by the DOR. Now, that has been rectified, Judge, going prospectively. The local assessors are locally assessing and issue local tax bills. So there's no more central valuation of cellular wireless carriers. The problem is going back in time, retroactively. There's a whole bunch of cases from 03 to 08 that we, City of Newton, filed our only administrative remedy under 5939. The court remedies, you know, declaratory judgment, mandamus. I mean, with all due respect, those of you that sat on Superior Court, can you imagine me coming in with a complicated tax case
Yes.
and I've got an administrative
Yes.
remedy?
Yeah, but you don't have an administrative remedy.
I did at that time. At that time, I did.
Then you go and you
because
say,
the commission-
excuse me,
I'm sorry,
Superior
Judge.
Court judge, and I know you're going to agree with me, those people up at the SJC or down at the SJC, whichever way you want to look at it, have just told me that I have to use up your time doing this because the appellate tax board, the commissioner can't do it. I mean, they may not like it, but why can't they do it?
Well, if I understand your question, Justice
You
Breyer.
answered and said the only practical way to do this is to go back to the ATB, correct? Because can you believe me going into the Superior Court? And I said sometimes the Superior Court judges have to hear things that, they don't usually hear.
You were just in front of Judge Conley in Suffolk Superior Court because Judge Cowan remanded another Verizon tax case down there. And Judge Conley started off the hearing saying, I know nothing about tax law. Pretend I'm in kindergarten and educate me.
Good start.
It's educable.
Given that that was our only administrative remedy at that time, because the commissioner had certified and classified them, Bell Atlantic Mobile, as a telephone company, jurisdiction did exist under 5939 because once classified, we've got the right to file a petition. And under 58, Section 2, any person aggrieved by any classification made by the commissioner under any provision of Chapter 59 allows a person to file an application with the appellate tax board. And the person is defined as shall include a board of assessors.
Okay, but
It's a classification issue.
The problem is you won. The problem is you won.
Prospectively, retroactively, no one envisioned that 5 years of cases would be thrown out
But it
with
is a
$400,000 of tax money that you and I have paid for. You and I have paid for that. This is a windfall to this industry that's occurred now for decades
Wait,
to the
just-
detriment
Okay.
of lawfully
All
paying
right,
taxpayers.
stop for a second. I mean, as a legal matter, though, once the board bifurcated and the issue went forward about whether it was or wasn't a telephone company, and once the court affirmed the board that it wasn't, you've got a real jurisdictional problem, don't you?
I don't have a jurisdictional problem. That's where the board erred in this. The board, that case, Dam 1, was about fiscal year '04 and '04 only.
Yes,
Dam
but-
2 is about '03 through '08. What are we complaining about, City of Newton Board of Assessors? We lost the exemption for 2 of those years. Boston lost the exemption for some of those years, $6.7 million because that exemption was erroneously granted by the Commissioner of Revenue to this company, and
Mr.
Boston lost
Mr.
millions of
Chemilins-
dollars. We lost hundreds of thousands of
Mr.
dollars.
Chemilinsky, let me ask you this.
Yes,
Is there
Justice
any statutory bar now for why you cannot obtain that relief what's the statutorily bar, not the practical bar, what's the statutorily, constitutional, jurisdictional, any other bar why you can't go to some place other than the ATB and get the money for the exemptions that were erroneously granted?
Time's over. That's why.
What's the
The
statute that says
deadlines
that?
are over for
What's
all
the
that.
statute that says that would be applicable? What's the case law that says the time's over when there was this peculiar, bifurcation?
I'll have the answer tomorrow, Your Honor.
Well, you,
don't know
you
as I
had,
stand.
you issued, I'm not sure it was you, but the other towns issued the other assessments, which they seem to have resolved under Section 75 as omitted assessments.
Under Section
And omitted
75,
assessments does have a deadline.
if there are clerical errors, data errors, or other reasonable grounds, we can issue an omitted assessment.
Right.
As Attorney Ambriano pointed out, Newton issued an
Right,
omitted
I understand.
assessment.
And there is a deadline under Section
After
75.
that
But there's
ATB
not under Section 77.
Again, Section 77 has to do when ab initio there was a local assessment. There was no local assessment here,
Where
a
does the
central
statutory
assessment.
language say that? I've looked at the statute. It doesn't say, it speaks of an assessment. It doesn't say an assessment that's initiated by the assessor.
Well, I think it does speak of assessment, and I
Right.
think Attorney Ambriano's point is well taken, that assessment under central valuation was issued by the Department of Revenue, not by the local assessors.
All right, and if we were to say, Newton, go back for these years and do your own assessment and let them challenge it under Section 65, would you be opposed to that result?
I think the time for doing so has long since passed, Your Honor. That's a conundrum we're in.
Meaning that you don't want to do that, or that we
No.
can't do that?
I don't believe we're legally permitted to do so. I think we'd be hit with a defense of, you're well past the time deadline.
What if we told you you could do it?
I'm sorry, Justice.
What if we told you you could do it? And I'm going to ask Bell Atlantic the same question.
Be happy to follow through if you gave us the green light.
Okay. Thank you, Mr. Chmielewski.
Thank you, Justice Marshall, and Your Honors.
Good morning, Mr.
Yes,
Reeves.
good morning. Doug Reeves for Bell Atlantic Mobile. If I could start by going back to Justice Botsford's first question about why they did not simply issue local assessments. Attorney Ambriano's response was, well, we couldn't do that until we had TIR 06-19 that was issued on October 16th of 2006. However, that can't be the trigger. And it can't be the trigger because the record shows that Newton issued its omitted assessment for fiscal year 2006 on June 16th of 2006. So 4 months before the alleged trigger, they actually issued that assessment. You've also heard that, well, we couldn't do that.
Was it after the, excuse me, was it after the decision of,
Yes.
it was after the decision?
After the ATB.
Of the ATB.
The AT, not the
correct.
SJC decision, yeah.
Yes, the ATB decision is May 5th of 2000, I'm sorry, May 15th of 2006.
And if before the ATB decision, they had given you their own assessment,
Yes,
you would have then had two assessments, one from the town and one from the commissioner.
no, actually, we would have only had one assessment because the local assessment can be based on the central valuation made by the commissioner, but we would still have only one assessment that we
So-
would then have.
But you're saying that what they should have done is they should have recognized the possibility that the commissioner had no authority to value it and provided their own assessment. Is that what you're saying?
That is correct.
And then you would have had then the Newton Town's assessment, which would have included the amount of the exemption, and you would have had the commissioner's assessment, which would not have included the exemption. And what would you have done? You have two exemptions.
Two evaluations.
You have two valuations.
We would have had a single assessment from Newton that we would have contested at that point. But
Because it was not complying, because it hadn't given you the exemption that at the time you thought you had from the commissioner?
yes, that would have been one of our arguments. But
Are you suggesting that Newton gets the value, I forget their dates in the statute, Newton gets the valuation from the commissioner and it includes the exemption, and then Newton is supposed to say, thanks, Commissioner, but we don't agree, and just ignore that and put its own assessment in the one bill that you get? Is that what you're saying?
yes, and I understand the description.
Do we
of that
know
as
of
well.
any towns that do that on any assessment from the commissioner?
Our argument is that they have that option.
Under what authority do they have that option?
Well, they have the authority because they have the authority to make a local assessment. And we think that the pattern here, the template for this strategy is the Holyoke case. And in the Holyoke case, the local assessor disagreed with the commissioner's classification determination and issued their own local assessment disregarding that. They also brought their own classification action under Section 2, which does permit the assessors to go to the board and say, we disagree with the commissioner's classification. The key here is, there are actually two keys. One, at this point, Newton is already on record saying the commissioner is wrong. This is not a telephone company.
When?
Count one.
No. How early?
How early? This is June 2003, Newton's fiscal year 2004, Section 39 appeal, count one, improper classification. So Newton is then on record as contesting the commissioner's classification of Bell Atlantic Mobile as a telephone company. So at that point, they have put the jurisdiction of the board the jurisdiction of the board under Section 39 at issue, and then have put at risk themselves their own Section 39 appeal by challenging that jurisdiction.
And if they had done that, then you would have received two assessments, one from the commissioner, one...
I'm sorry, I didn't mean to interrupt, but...
You would have then had two different assessments.
No, we would not.
How would you have not had two assessments if you say Newton should have assessed you at full value?
Yes.
And the commissioner should have assessed you with the exemption? That means two valuations.
Because the commissioner does not assess. The commissioner does a central valuation. The central valuation is provided by notice to the cities or to the assessors. The assessors then make a valuation that, under the normal circumstance, is based on the commissioner's central valuation. That's the ordinary course of things.
And what would you have done? Would you not have said Newton has no authority to be valuing it? Because
Absolutely. And that
Right.
would have been our 65 appeal. We would have said Newton has no authority because we are a telephone company.
Right. So you're saying that Newton should have done something for which,
And yes.
Well, they would have won.
And
They
in
would
the
have
end-
won.
and in the
Newton
end
would have
they-
won,
Exactly,
which they did.
which they did.
You mean,
And
are you
that was
saying
the
that
way to
Newton
do it.
should have, that Newton in 2004 should have had both a Section 2 proceeding and a Section 39 appeal? Is that what you're saying?
The Section 39 appeal, well, they could have issued a local assessment. They also could have
Your
brought...
Section 2 of
No, just under their general assessment authority. And they also could have appealed the classification under Section 2. If they, and this, again, this is the template that's provided by the Holyoke case, that
You just said, but you said to Justice Gantz, we only get one bill.
yes, we only get one bill.
So how can they have,
Well, I'm not making clear. We get one bill. Newton would send us one bill based on their own local assessment. We would then contest that.
Under Section 65?
Under Section 65, precisely. We would pay it, we would proceed for abatement, and one of the issues would be, in that case, are we a telephone company? So Newton could say, well, that's where the telephone company issue is going to be decided. However, if they wanted to push it, they could have filed their own Section 2 appeal, which, as Attorney Chmielewski says, any determination made by the commissioner can be appealed under Section 2 with respect to classification. So they could have addressed the telephone company issue under Section 39. They could have addressed whether we are a utility corporation under Section 52A in that Section 2 appeal, which is the trigger for the corporate utility exemption. So that is really the option that they had.
Okay, and how are you prejudiced if we were to say to the town of Newton, go now do your own valuation for these past years and let you challenge it under Section
65?
65? How are you prejudiced? You had noticed that they challenged the commissioner's assessment way back then. They've always challenged that amount.
Yes.
How are you prejudiced?
In that case, we would be prejudiced by them proceeding without statutory authority to make that assessment.
Well, that's
what's the-
conclusory, but
That is
how
conclusory, yes.
pragmatically, how are you prejudiced? Why are you worse off pragmatically or equitably?
Well, I guess my response to that is that And just to step back and look at the statutory scheme here, this is an annual tax. It's determined annually. There are very limited rights of the assessors to assess the taxes under very short time periods. There are very limited rights of taxpayers to contest those assessments. Again, very short time periods. So you have these very narrow periods that occur annually. And if those statutory deadlines are blown, then the system really does not contemplate going backward.
But you were contesting it anyway under Section 39. You knew you had a contest. You knew that there was going to be a dispute, and you knew way back then that there was going to be a dispute. It was just going to be under Section 35 as opposed, 39 as opposed to 65. So it's not as if you had no idea that there'd be a conflict. There is. There always has been. They think you should, they think that you're entitled to the exemption. So why are you in any worse position now than you, I mean, if that had happened, then you'd be, if you had resolved it under 39?
I think that we're in a worse position in that there was no basis for them to make that assessment. I mean, in essence.
But what do you mean there was no basis for them to make that assessment? Back then?
No, well, if you look at the basis, the jurisdictional basis that they alleged to appeal.
No, I
to
understand,
the
but
board, yes.
to go pragmatically, you're saying because they didn't do it back then, it's a purely jurisdictional argument you're making, which is not to say it's not an important one.
Yes, it is we are making a jurisdictional argument.
You say not having taken the Section 2 path of appeal,
Yes.
they have essentially waived the right to collect anything that might have been owed under an exemption.
They have never made any claim, outside of Section 39.
But isn't this really hasn't this arisen because of the board's decision in whatever year to bifurcate and to decide separately from the rest of the Section 39 appeal the question of whether you were or weren't a telephone company? In other words, if the board had proceeded with these Section 39 appeals, all as of a piece, we wouldn't be here, because they would have said, you're not a telephone company, no corporate utility exemption, therefore, whatever it is that the towns were saying would be found, and you'd have to pay these other taxes, wouldn't you?
Well, actually, let me contest the characterization of what the board did. It didn't actually bifurcate the Section 39 appeal,
Oh, I understand that.
but it actually considered everything that was brought under Section 39, and I think this is important, and it goes to the issue of jurisdiction and whether things were dismissed. What the board did on May 15th, 2006, if you look at the decision, they said, we are deciding one thing. We are deciding under count 1 of Newton's fiscal year 2004 Section 39 petition, count 1 improper classification. We are deciding that threshold issue in their favor. Now, Newton also, count 3, had a claim for undervaluation. Now, even though the commissioner did not provide BAM with the benefit of the corporate utility exemption, there was still a valuation. It was a big valuation. In Newton, about $6.1 million. So Newton's count 3 was claiming that 6.1 should have been something higher. At the same point, BAM had its own Section 39 appeal, and it made the reverse claim, said that 6.1 is too high. BAM also claimed with respect to the exemption that the exemption should have been granted. So those were the Section 39 appeals. And what did the board do on May 15th, 2006? It decided in favor of Newton on count 1, classification, and it said with respect to everything else, we can't reach those issues because Section 39 does not apply. Now, in their reply brief, the assessors have claimed that we have misrepresented what the board did back on May 15th, 2006, that there was no jurisdictional issue, that nothing was dismissed. But if you look at the timeline, June 3rd, 2003 through May 15, 2006, there were active valuation claims, active exemption claims filed under Section 39, both by Newton and by BAM. Those claims were alive, well, and kicking from the time they were filed until the time on May 15, 2006, when the board finally disposed of those claims. And that disposition was upheld here by this court's BAM decision, affirming that decision. So it was a jurisdictional decision. It also resulted in claims being dismissed. And if you think, well, what would have happened to these claims that are here today if they had been consolidated with those claims?
I'm sorry, you lost me on the these and the
Sure.
those. These claims
These
here today
claims,
with...
the Section 39 appeals by the assessors for 05, 06, 07.
Right.
Just consider hypothetically, if the board had
Yeah, no, I'm
hypothetically
with you now.
consolidated those, they would have met the same fate. They would have met the same fate. So what are the assessors actually asking for here? They're really not asking for those claims simply to be fed back into the process and run through the Section 39 mill. It can't be that, because if they were asking for that, the board would look at the claims and they would say, well, wait a second, this is still not a telephone company. Section 39 does not apply. And as we decided on May 15, 2006, with respect to those Section 39 claims, we cannot reach the exemption issue. We cannot reach the valuation issue. We simply do not have, and I'll use the same word that we used in our brief, we don't have jurisdiction. And
But
those
they would
claims
have
be
jurisdiction
dismissed.
under Section 65 with regard to your appeal. They would have jurisdiction under Section 65 to review your claim that the assessment is too high.
We only have Section 65 appeals, or had them pending with respect to fiscal year 2008, which are moot. Those have been settled. So for the only non-moot claims here, there are no Section 65 appeals that are pending with respect to
And that's
dams.
because you thought that you were operating under Section 39.
No, that's because we had no reason to contest the commissioner's valuation when he applied the corporate utility exemption. So that we were okay with that.
Right, okay, so you were happy with that.
We were fine on
valuation.
that one.
What would you say to Justice Gaines' question? Is it Section 77? Whether the cities and towns could use that to sort of fill in what hasn't been these other years?
Yeah, and I apologize. I don't have a good response for Section 77 because nobody has raised it as a possibility before
know.
this morning. So I wish I had thought of that and had a response, but I don't.
Mr. Reeves, you understand what is troubling the court is essentially the last point made by Mr. Ambriano or Mr. Chmielewski, I can't remember which, that it feels like a windfall. And you're saying we don't have to view it that way because there were other steps the town could have taken at the time. It didn't take those steps, and it's not a windfall. They just went in the wrong door.
Yes, and that goes back to the character. If you step back and look at the system, I mean, because of the short and limited time frames for appeal, there is no special appeal right that applies when you have determined that there is a windfall. I mean, if you think about, the corporate utility exemption, for example, was applied to wireless companies for more than a decade before 2004. So I guess you could say, well, that's a windfall. Is there any way to go back there? Well, no. And whether it's a windfall or not really doesn't make any difference.
Okay.
Well, all that makes a difference is what are the statutorily defined rights of appeal
In any given tax year.
in any given tax year.
Okay. Thank you, Mr. Reeves.
Thank you.
We'll take a short break, please.